Judge will just be one more minute.
That's okay, thank you.
Yep. Good morning.
Good morning.
Good morning.
All right, we're on record under 29 DL 11409 DR 8739 Gazaldo versus Wilson. We're here for case management conference. This is Judge Casati. We're on the record in Hamilton Superior Court 1. I've reviewed your motion, Ms. Willis. What is your suggestion?
Well, Judge, I guess first I had some questions in terms of we've already had 3 hearings on the pending motions of different lengths on different issues, and I wanted to first determine, are we going to have you rehear all that evidence, or are we picking up where we left off? Because I think that will in part determine how we move forward. We also have several other motions that haven't been heard yet.
Ms. Wilson, what is your position as to that?
My position is to seek calendar control and enforcement. Opposing counsel has refused to confer despite multiple dated requests. And I just ask that we set a shortened time for my show cause and child support modifications and assistance-related orders.
Hang on a minute. I asked you what your position was with respect to whether or not the court listens to the record and that we go forward based on the evidence that's already been presented, or whether we start anew.
I guess I am confused. Are you asking for a trial de novo? I don't understand what start anew means, because they destroyed evidence. They destroyed evidence in my trial. They admin Rule 7 all of my protective order evidence that had to do with my sexual assaults and my rape. So
Hang on a minute.
yeah.
All I want to know is I cannot, as a new judge in this matter, listen to the prior record and consider that evidence unless the parties agree. So the question is, am I going to listen to the prior proceedings and review the evidence that was presented in those prior proceedings?
Yes.
And then,
I believe that's the only way I can get a fair trial. Yes, that needs to happen. It needs to be reviewed from the beginning.
Well, it's not, no, I don't review from beginning. I review, Ms. Willis referred to 3 prior hearings. Is that correct, Ms. Willis?
Yes, the first one was in July of 2024, and there's been 2 since then.
Okay, so the question is,
I don't agree with that. I want the full docket. I don't agree with that at all.
Well, I will, the question before me is whether I listen to the record in those 3 hearings, and then we have additional hearings.
I don't think those are the hearings that are in question right now. The hearings that are in question that I have requested a stay to try to prevent harms that have been caused to me by what has been done by Ms. Willis have not been addressed. And I think that going back 3 is not far enough, because we need to go back to when I was put in jail for standing up to a judge who was violating my constitutional right to finish cross-examining the psychological evaluator who got on the stand and perjured herself and had not even finished a psychological evaluation, yet still sat there and and gave a report with speculation. And it's definitely my consideration right now is that needs to be, all these experts need to be put under Daubert tests, and their supposed evidence that they have paid so much money to have put into this case to wrongly to make these false statements about me. It needs to be addressed that these so-called experts are not experts in domestic violence. They aren't experts in coercive control. They aren't experts in parental alienation. They aren't experts in trauma. They aren't experts in the things that matter in this case.
Judge, Ms. Wilson is speaking about incidents and evidence that was given in October of 2023. That matter has been resolved.
No, it has not.
Order.
No, it has not. They took me out of that courtroom and put me in jail, and they continued it without my presence. And they filed an order that...
Ms. Wilson?
Yeah.
Ms. Wilson, I asked for Ms. Willis to speak.
Okay.
I did not ask for you to speak yet. You will have the chance to respond. Ms. Willis, go ahead.
Thank you, Judge. It is true that Ms. Wilson was arrested during that proceeding and did not continue in her absence. The court concluded it after her arrest. Nonetheless, that issue was decided. There's been no expert testimony presented in the matters that are pending. In fact, we've only had one non-party witness who was a Carmel police officer in the 3 hearings that have occurred and what's pending. So what she's talking about is evidence and hearings from issues that have already been decided and closed that doesn't have anything to do with what's currently pending.
Without discovery, Your Honor. She did not proceed with discovery. She did not do 26F. She did not follow tribal procedures. She is not following the book.
There's been no discovery by either side since the motion that started these proceedings.
Because I have been made homeless, Your Honor. I've been put in extreme hardships by this woman's unethical and irresponsible behavior. And I do not feel safe conferring with her. In fact, I don't feel like she could ever certify any sort of good faith in this court with me.
Okay. So, Ms. Wilson, do you know the exact dates of the 3 prior hearings?
I do, Judge. The first one was on July 2nd of 2024. The second one was January 13th of 2025. And the third one was April 24th of 2025. We did have one additional proceeding in September of 2024. No evidence was given. Ms. Wilson asked for a continuance and the court granted that. So we were in court, but nothing
But
occurred.
I also want to bring up, Your Honor, that there are issues with vacating motions that the magistrate had no right to order.
All right, ma'am, I'm not on that right now.
Okay.
I'm on the hearings, okay? Now, she just recited the 3 hearings that occurred. The question is, do you want me to review the record from those 3 hearings or not? Is it yes or no?
Yes, but I don't think that's going to satisfy the...
It's not the end. It's just part of the record, okay?
The entire docket should be reviewed.
The court will go ahead and review the record from July 2nd of 24 of the approximate amount of time that each of those hearings were conducted?
Judge, vaguely I do. The first hearing, I think, was set for maybe 2 to 3 hours. It was not a full half day that I recall. January 13th was a half day. The April 24th was supposed to be short, and I think it ended up being longer. I would say at most they're all a half day.
Okay.
Your Honor, can I bring up the need for communication protocols and court facilitated meet and confer along
What do you
with
mean, communication protocol?
some sort of relief where I have email only communications and one point of contact with Kylie Willis, and that she is required to respond within 2 business days, and that there's a monthly 20-minute court supervised status conference, some sort of motion to compel cooperation and set discovery conferences, because it's been
There's
delayed.
No discovery pending. So,
There is discovery pending. Discovery was never completed. I was forced into mediation as a domestic violence victim, and you're not looking at this from the beginning.
no, I'm not looking at it from the beginning. I'm looking at what's pending before the court, because that's how it works.
And I have tried repeatedly with the clerk's office to file a protective order into my divorce, and they have obstructed that repeatedly.
You can't file a protective order into a divorce case.
My protective order is enjoined with my divorce case. My protective order, my original protective order, is consolidated with this case.
It cannot be. It has to be a separate cause of action.
It isn't. It was the first cause of action before he even filed for divorce.
Is that the one that you said that I heard?
No, that is the one.
The protective orders she's referring to are from 2014, and they were dismissed, both of them. There were 2.
I was forced to dismiss them after
18 or 19.
it was not.
All right. Well, they're not before. The motions before me were outlined in the motion for case management conference. Okay. So, Ms. Willis, do you have a suggestion as to how much time is needed of the court's time
Well, Judge,
after I review the record from the 3 prior hearings?
I do, but I think that also depends on some other of the pending issues that are outstanding. So I don't think the issue of whether Ms. Wilson is being appointed an adult guardian ad litem has been resolved. And so I think
I have objected to that, and I don't think that's appropriate at all.
and I don't have a position on it, but it was ordered over her objection. And then there's also the position, the issue of whether or not she
It wasn't ordered over my objection. It was ordered, and then I objected. That was the wrong order in which it took place.
I'm not clear on what you're talking about.
Judge Barta tried to put a guardian ad litem over me because I told him that the domestic violence and the experiences that I continue to have to be put through by this court and the re-traumatization continually cause me to have more problems, as would. And so it is very incapacitating to have to do this over and over again, now going on 11 plus years.
Ms. Willis, can you enlighten me on what this is?
I can't judge.
I don't think Miss Willis is my best form of enlightenment. I'm sorry, but I feel like you're giving her more, you're listening to her more than you're listening to me.
I'm listening to both of you.
I don't feel listened to.
One at a time as I direct. That's how it works.
It's not working.
Ms. Willis?
Thank you, Judge. I filed a rule to show cause against Ms. Wilson in December of 2024. The court appointed her a public defender. During the hearing, we separated the issues because she was only representing Ms. Wilson on that particular matter. So we separated the hearings, and during that hearing, her public defender asked the court to appoint a guardian ad litem for her.
subsequent filings were me pleading that my public defender was inefficient counsel. That guardian ad litem should never have been.
Talk right now.
Yeah.
Go on, Ms.
Well, she's leaving stuff out.
Thank you, Judge. So we had a status conference. Ms. Wilson was present,
Intentionally.
Mr. Counsel, Ms. Mattingly, and myself with Judge Block, where that was discussed. He ultimately
Without me there.
issued the order appointing the guardian ad litem over her objection, but not at my client's cost, and Ms. Wilson couldn't afford it. So he instructed Ms. Mattingly to contact a couple of agencies because the Hamilton County program declined to do it because they previously represented the child in this matter.
Well, it's more than that. They represented the child, they hired the mediator, and they also employ his previous attorney. Okay.
You will have a chance to talk, but I want to hear from Ms. Willis first. Stop interrupting.
There's huge conflicts of interest in this case.
Go on, Ms. Willis.
Thank you, Judge. So where that was left after that conference is that Ms. Mattingly was supposed to reach out to some agencies to determine if anyone was willing to provide that service, and then Judge Block was going to look at whether the county could pay for it. After that, Ms. Wilson asked for her counsel to be removed for, I'm thinking...
No, I never asked for her to be removed. I said that asking for... She's misstating the facts, and I have a right to correct them.
You will have the opportunity after she is...
I will forget. I am a trauma victim. I don't remember. I have to say something, otherwise I will forget.
Ms. Willis, go ahead.
Thank you, Judge. Since that time, Judge Block removed Ms. Mattingly as the public defender from Ms. Wilson, and nothing's ever occurred. He ordered Ms. Wilson to file something about her efforts to find counsel for the contempt. That's not happened.
Yes, it has. I have contacted over 200 attorneys, and you know nothing about what you're talking about, and you should not speak of things you do not know. Keep your assumptions to yourself.
She's not filed what he requested, what he ordered that she file, so we don't
That is not true.
the status of whether she has an attorney for her contempt, and there's been nothing done about
I don't have money for an attorney, and that is not true, and he knows I'm indigent, and she is misrepresenting the facts. She knows I'm homeless. She knows I've lived in my car for a year and a half. She is lying.
All right, so what was the issue on the contempt that you filed 12/24?
The issue was that in the October 2023 order, Ms. Wilson was ordered to not post on social media or online information about the case, and there's been, allegedly, we've alleged that there's been a lot of posts on her social media, Instagram, LinkedIn, Facebook.
Oh no, they've been stalking me. I am stalked by this woman and my ex-husband.
Other information about the case has been shared on public social media platforms. That's the only issue that was. Oh, and a couple of other things like using a child's inappropriate name and things like that. Just some minor things.
That's not the child's inappropriate name. She was born Alexandria Wilson. He had it changed, and I was forced to change it while he stole everything I owned. I will not have somebody tell me what to say my child's name is. I will not.
All right, so let's get back to the setting of an additional hearing. Ms. Willis?
So my point was, I think whether she's going to have a public defender or a guardian ad litem would impact the time, as well as the fact that if she's going to have a public defender on that issue only, then we would be having to do what we were doing before.
I don't understand why I'm being talked about in third person, as if I'm not even here.
Go on, Ms. Willis.
Thank you, Judge. My belief is, my count is that my original motion and my contempt, and Ms. Wilson has at least 6 motions pending, not including the several she filed in August that haven't been ruled on yet.
That's a common thing. A lot of my stuff has not been ruled on and was failed. And then the clerk interfered with my appeal, refused to produce the record. I've had all kinds of trouble getting the actual timeline and the actual records for my case so that I can properly appeal. This has not been, there has been a lot of obstruction in this case.
Ms. Willis, go ahead.
Thank you, Judge. Because these proceedings tend to go the way this is going currently, I think it will probably take 2 full days.
It's going to take longer than that, Judge, for this to be adequately sussed out. There are a lot of witnesses that I want to have testify.
All right, I'm looking at the calendar.
Discovery is going to take a lot longer than just 2 days.
Okay, I can give you 2 days in March 2nd and 3rd.
That's fine, Judge.
Does that work for you, Ms. Wilson?
I don't think that's going to work for me because I am going to have to figure out how I can obtain state-funded services to complete my discovery and my depositions. And get a hold of the deposition that was made by his attorney, Brooke Jones, that has magically disappeared.
Well, if we set it in March, you have about 5 months to do that.
It's been 11 years and I haven't been able to get that. So I doubt that I'm going to be able to get it done in 5 months when I need state assistance in even completing this, and I have requested accommodations from your ADA at your courthouse and repeatedly had them refuse to help me with my issues pro se. Yeah.
All right. Are we feasibly going to be able to conduct this in 2 full days consecutive?
I don't believe so. I don't think it's going to take 2 days. I think it's going to take longer. There are a lot more people that I want to testify on my behalf.
Ms. Willis?
I would like to think so, Judge, especially if you're listening to the record from the first 3 hearings. Some of Ms. Wilson's
No,
motions
because
are
discovery was not completed.
duplicative.
All right. Okay, for now, the plan will be for me to review the record of the 3 prior hearings, consider the evidence that was presented, and then we'll set this for 2 additional full days. March 2nd and 3rd of 2026 will start at 9 a.m. each day, and I'll get an order out on that.
What about my current rule to show cause? Is that my emergency, request to be able to see my kid every other weekend? As ordered.
These are all being heard together.
No, that is not okay. This is an emergency situation and this needs to be much further up than March 3rd. I'm not going until March 3rd without seeing my child every other weekend as court ordered, without a hearing.
Ms. Willis, what's going on with respect to, what is the current order with respect to parenting time and what's taking place?
Judge, the current order is from October 2023, which is that Ms. Wilson had alternating weekends and some
ITPG.
That was pending is our motion to suspend parenting time because of danger to the child.
There is no danger to the child. It is inflated, and there is no substantial evidence. There is.
I'm not here to hear the argument.
I am not arguing. I am simply stating that what she's saying is not true.
That's an argument.
That is speculation. She's not allowed to come here and speculate.
All right. So go ahead, Ms. Willis. What's pending?
Thank you, Judge. The motion that started this whole thing was to suspend Ms. Wilson's parenting time due to danger to the child. My client will admit that he has not allowed her to see the child since that.
He hasn't allowed me to see her, talk to her. He's also court ordered to let me talk to her every day I don't have her for 10 minutes between 7 and 8 o'clock. He has disparaged me. He has alienated her from me. I have not heard from my daughter regularly. When I do hear from her, he's watching her. He's making sure she's not talking to me. I have been prevented from having a relationship with my child by this man, and it is an emergency situation, and this court should not wait until March 3rd to have a hearing on that.
Go ahead, Ms. Willis.
Thank you, Judge. Ms. Wilson has filed a contempt against my client for not allowing her to see the child. They do have some communication, and she has requested parenting time, and they've tried to discuss it, but because she's homeless, she requested that my client pay for a hotel for the two of them for a weekend.
Oh, that's not the only thing I requested. I also requested that he bring her to the hotel that I paid for. And he didn't bring her to the hotel to spend Thanksgiving with me, my Thanksgiving. And he didn't bring her to the hotel that I paid for to spend my Christmas with me either. And he took my birthday time with her away. And he took my Mother's Day with her away. And he, yeah. And there is no reason for it. No reason. No good reason. No substantial evidence. And in fact, the Hamilton County DCS has found substantiated evidence that he is abusing, that she is being abused by him and his wife. So I don't want to hear that this needs to be heard all the way out to March 3rd.
Well, you were just telling me that you wouldn't be ready.
I'm not going to be ready to cover everything. There are several different issues that have been filed with this court. But this issue, me not being able to see my child and me being kept from doing family counseling because he's saying that I don't go to individual therapy and that he has to talk to my individual therapist and that he has to have a letter from my individual therapist. I went and paid $1,600 to an individual therapist to have sessions, and she had sessions until she felt like we could participate in family counseling together. And you want to know what the court did? They took Miss Willis's filing for restraining me from taking her while she was suicidal. She had been diagnosed with suicidal ideation, divorce trauma, all kinds of stuff that is still going on right now, and you're letting it happen, and you're waiting till March, and you're letting her delay this. And you don't know the whole story, and that's why you can't go back 3 hearings and have the child's best interest in mind. It's impossible.
Ms. Willis, was there evidence presented at these 3 hearings that's relevant to the motions, her emergency motion, and the motion to suspend parenting time?
We started the first hearing was on the motion to suspend.
The motion to suspend parenting time was denied. He did not allow that to go through. That is not still in the court. He addressed that. The judge filed in his order that is not even still an issue. She is bringing up things that have already been handled by Andrew Block and making them a motion that's still in play, and that is not the truth.
Ms. Willis, go ahead.
Judge, the first 2 hearings were on the motion to suspend parenting time.
block shouldn't even have been on my case. But we won't go there either, Willie.
Okay.
Yeah.
So, how much additional time would be needed just to address complete the evidence on motion to suspend parenting time in her emergency motions? Ms. Willis?
I think it depends, Judge. I think the hard thing about this is that all of her pending motions are related to each other because hers are for modification and that has something to do, it's all interrelated in terms of she's filing contempt about not seeing the kid, but we think it's unsafe for her to see the kid.
That is not true. Nobody has came and said that. Nobody has said that. Only the person who is currently abusing her has said that. Only the person who has substantiated reports of abuse against her and now has sole legal and physical custody of her has said that. And his attorney. And they also have refused to provide me with her medical information. They have refused to provide me with the therapist that he is having her see. I have requested repeatedly for that therapist's information and to know what that therapist is being provided for my daughter's care. And they have refused to share that information with me.
That's not true.
That is true. I have the emails. It's in OFW. Is right, Miss Willis.
What is...
And I have a right. I have a parental right, a constitutional parental right to know what's going on with my child's health. And you do not have the right to withhold that information from me after you have already sabotaged her health care.
Ms. Wilson?
Through frivolous orders and frivolous motions that have defamed me and put me in a bad light that's completely untrue.
All right. What about availability on the 28th of October for half-day hearing in the afternoon?
October when?
October 28th.
28th. Well, her birthday's on the 14th, so am I going to miss another birthday? Because he's already taken 4 Christmases from me and three Thanksgivings that were mine. And he's also now decided that he can claim her on taxes and has ruined my taxes.
Ms. Willis, are you available on the 28th?
I am, Judge.
Yeah.
Okay.
It's financial sabotage, too. And employment sabotage. That nobody cares. Nobody wants to protect me from it.
For a hearing on the afternoon of October 8th, just with respect to the motion to suspend parenting time to collect evidence on that and mother's emergency motion for parenting time. And then I will also be setting this for 2 full days on March 2nd and March 3rd.
How long is this hearing on the 28th?
We'll start at 1:30.
And do I have the right to do discovery? Am I going to have time to do discovery for that?
Well, on one hand, you're telling me you need to get into court. It's an
I
emergency.
do need to get into court, but I also need to have discovery done. So how am I going to have discovery done? How am I going to get that done? How am I going to get those depositions done?
Do you want me to not set it on the 28th?
I don't know how I'm going to get depositions and discovery done by the 28th, but it is an emergency to me. And it has been. And my whole life has been destroyed by this woman who is sitting on this phone call today. So I and my ex-husband.
Go to hearing on the 28th or not?
I won't be able to get discovery finished by then, I don't think, if we don't have a plan in place in the case management to figure out how I'm going to get discovery done. If I don't have some sort of reasonable accommodation for my trauma and have a way to figure out how to get this finished and get all the evidence and not have it
thrown out from court.
Documents or interrogatories.
Right, but I have to send them to people, right? Like, I'm pro se. I can't continue doing this. I don't know how I'm supposed to even get discovery. I send discovery. I sent a subpoena for all my child's phone records because he was talking to her behind my back without permission in off times before he filed false reports with the police.
Hey, ma'am.
And he didn't have to respond to that subpoena. Nobody did anything to him when he did nothing for that subpoena. And then I ended up here somehow.
Yes or not?
I'm sorry.
Do you want to go to court on October 28th or not?
I want to be able to figure out how I can get discovery done.
The question is, do you want to go to court on October 28th?
I do, but I want to know how I'm supposed to do that if I can't get discovery done. And I don't have any expert controls in order. And she says these people who testified, who provided these reports aren't experts, but they were. They were experts. They were a psychological evaluator. She was supposed to be an expert in my psychological status. And she didn't have the criteria that needed to be met under Daubert and Fry to even sit on the stand and do what she did to me. So I don't understand how those things aren't being addressed first. I don't understand why we aren't dealing with the Daubert and Fry issues first, because that is what got...
Those issues aren't before me.
Why not?
Because they're not before me.
Why not?
Because they're not before me.
But I don't understand why.
Do you want to go to court on the 28th or not?
I want a Daubert standards challenge before going to court.
I'm setting a hearing on October 28th at 1:30 p.m.
So I just need to file for that then and have you deny it and then go appeal it? Or, I have the right to that.
You might consult with maybe the neighborhood legal clinic.
I have done that. Nobody has offered to help me.
All right.
Nobody. I have contacted over 200 attorneys, and I have still not found legal counsel. But I have been told that what has been done to me is complex and very egregious, and there are a lot of people that have done bad things.